Information about who is eligible and how to ask to have a felony conviction dismissed or reduced. Whether you're eligible and what steps to take depend on many factors, like what the conviction was for and what your sentence was. Paths to dismiss a felony conviction. You can ask to have your felony conviction dismissed if both. If you are still on probation in the case, you must also ask for early termination from probation, under Penal Code Section 1203.3. Depending on your sentence, there are 3 paths to dismiss a felony conviction. If you satisfied the terms and conditions of your probation, or if you were granted early termination of probation, the court must grant your petition to dismiss. If you did not satisfy the terms and conditions of your probation, it is up to the court whether or not to grant your petition. You may attach supporting documents to convince the court that granting your petition would be, in the interests of justice. You can ask to reduce the conviction to a misdemeanor if the offense is a wobbler. Penal Code Section 17(b). A wobbler is an offense that can be either a felony or misdemeanor. To find out whether you were convicted of a wobbler, you will need to look up the code section for your conviction. If the code section mentions county jail as a possible sentence, then the offense is a wobbler. If your sentence included mandatory supervision, the case can be dismissed 1 year after you complete your sentence. It is up to the court whether or not to grant your petition. You may attach supporting documents to convince the court that granting your petition would be, in the interests of justice. If your sentence did not include mandatory supervision, the case can be dismissed 2 years after you complete your sentence. It is up to the court whether or not to grant your petition. If you were convicted of a felony offense and served time in state prison, but the same offense is now punishable by a county jail sentence due to a change in the law, you can ask to have your felony conviction dismissed. It is up to the court whether or not to grant your petition. You may attach supporting documents to convince the court that granting your petition would be, in the interests of justice. For all other felony convictions with state prison sentences, you are not eligible to have your conviction dismissed. But you can apply for a certificate of rehabilitation and pardon. Certificate of rehabilitation. A certificate of rehabilitation is a court order that says someone who was 1. Convicted of a felony and 2. Served time in state or local prison, has been rehabilitated. It does not erase your criminal record. But, it can have some benefits. For example, it may help when you're applying for a job or professional license from the state. There are laws about what an employer can ask about or consider related to your criminal history when you apply for a job. One of these laws is called the Fair Chance Act. In general, rehabilitation means that for many years after your conviction, you lived an honest and upright life, followed the law, and showed good moral character. See Penal Code Section 4852.05. It's also a first step to applying to the governor for a pardon. If you get a certificate of rehabilitation, it gets sent to the governor's office. It is considered an official application for a pardon from the governor. What it can do. Who can apply? To apply for a certificate of rehabilitation, you must meet each requirement. 1. California residency requirement. You must have lived in California continuously for the past 5 years prior to applying. If you do not live in California, you can ask for a pardon directly instead. 2. Required waiting period, at least 7 years. This is how long you have to wait after you're released from jail, prison, parole, or probation before you can apply. This is called the period of rehabilitation. During this time, you can't get in trouble with the law and must make significant improvements in your life. The period of rehabilitation is the 5 years of California residency, plus an additional few years based on your conviction. Generally, it's 2 to 5 additional years. The period of rehabilitation starts when you're released from jail, prison, probation, or parole, whichever happens first. This means in general, you can't apply unless it's been at least 7 years since you're released from jail or prison. You can find the wait periods in California Penal Code Section 4852.03. 3. Convictions that qualify. Generally, only those convicted of a felony are eligible. There are some exceptions, discussed below, for those who have misdemeanor sex crime convictions. Felony convictions and went to state or local prison, except for certain sex crimes. You must also be off parole, post-release community supervision, or mandatory supervision. Felony probation, except for certain sex crimes. You must have your case dismissed, expunged before you can apply. You also can't have gone to jail or prison since you got your felony dismissed or be on probation for another felony. Felonies or misdemeanors involving sex crimes listed in Penal Code Section 290. You must have your case dismissed, expunged before you can apply. You also can't have gone to jail or prison since you got your case dismissed or be on probation for another felony. There are some people who can't get a certificate of rehabilitation. You are not eligible if you are currently in the military or if you live out of state. You also don't qualify if you are on mandatory life parole, have a death sentence, or are convicted of sex crimes involving a minor.